There are a lot of different ways to win a case. One of them is to plead not guilty. If you turn up at court and you say, I'm not guilty to drink driving or dangerous driving or driving while disqualified, the case will usually go off to a preliminary hearing first for everyone to make sure they have the evidence, and then it goes off to the actual hearing with the judge. So what basically happens is the judge will be sitting up on the bench, you'll be sitting there with your lawyer, and the police prosecutor will be there with the police officer who charged you and any other witnesses. So they get up and tell their story first, and you have the opportunity to challenge them, and at the end of their evidence you can see if you can get the charge thrown out. If you can't, you can then decide if you would like to get on the stand and tell your side of the story. Now the thing is, if you win that hearing and the judge says they cannot accept that beyond a reasonable doubt you're guilty, then it's over and you walk. The problem is if you're found guilty by the judge, you're looking at a more serious penalty than you would have if you'd pled guilty early on. But that said, it's very important to understand that there are still ways of saving your license that I've outlined on this website, even if you're found guilty. You're still eligible for a work license. You're still eligible for community work in lieu of disqualification, and you can still look at special reasons. So it's one of those things where when you're talking about winning a case, as I've already written on the site, you need to decide what do you mean by winning. To go through a whole defendant hearing can cost you a lot of time and money, a lot of time off work, and if it's really just about saving your license, there might be an easier way to do that. That said, if you're facing a traffic charge and you're worried about your license, or you think you might want to defend it, feel free to get in touch and we'll have a look at your options.